Second reading debate is adjourned and the bill is referred to the House Committee.
Government bills. This Council resumes the second reading debate on the Trademarks Amendment Bill 2019. The Honourable Ting-kwong, Chairman of the Bills Committee on the Bill with Affairs, addressed the Council on the Bills Committee's report. The Honourable Ting-kwong. Madam Deputy, in my capacity as Chairman of the Bills Committee on Trademarks Amendment Bill 2019, I'd like to make a report of the deliberations of the committee. The bill seeks to amend the trademark ordinance to A. To make procedural rules for implementing the Madrid Protocol in Hong Kong. B. To confer powers on the Customs and Excise Department to enforce the criminal provisions in Tiempo, and C. To make miscellaneous technical amendments to enhance Hong Kong's trademark application and registration system. The Bills Committee has held 2 meetings to discuss the bill with the administration and to hear from deputations or individuals. Members in general concur that upon the implementation of the Madrid Protocol, the one-stop application process will simplify the registration process, and businesses will obtain and manage international trademarks registration in a more convenient manner. The BC discussed, among others, processing of an international application upon implementation, the CPG's support to the application of the Madrid Protocol to Hong Kong, separate arrangements to facilitate reciprocal filing of trademark applications between Hong Kong and the Mainland, and enforcement powers for the Customs and Excise Department. The BC notes that upon the implementation of the Madrid Protocol in Hong Kong, a local applicant may obtain protection of a trademark in multiple jurisdictions through an international registration by filing a single international application with Whelmed Intellectual Property Organization in lieu of individual filings in each of the jurisdictions concerned. Members in general concur that this one-stop application process would definitely simplify the registration process, thus facilitating Hong Kong businesses to obtain and manage international trademarks registration in a more convenient and cost-effective manner. In the course of deliberation, the BC sought details of the processing of an international application upon implementation of the Madrid Protocol in Hong Kong and the fee schedule for such applications. The administration has advised that under the international registration system of the Madrid Protocol, referred to as Madrid System, an applicant is not required to file an individual application in each jurisdiction. Instead, the applicant will seek to obtain local trademark protection in other contracting parties to the Madrid Protocol by filing an international application via the Trademark Office of Origin, paying one set of fees and designating one or more contracting parties in which the protection is sought. Upon receiving the application, the Office of Origin will forward it to the IB, that is, International Bureau of WIPO. IB will check whether all the formal requirements are met, and, if yes, will notify the Trademark Office of each designated contracting party. The Trademark Office of each designated contracting party will then examine the trademark concerned in accordance with its domestic trademark laws and practices in considering whether the local protection should be provided. Regarding the fees scheduled for an international application filed in Hong Kong, the administration has advised that the fees comprise A, the fees charged by the Hong Kong Trademarks Registry or the registry for processing the application, which will be subject to the user pays principle and on a full cost recovery basis. B, the fees charged by IB of WIPO, and C, the fees charged by the trademarks offices of the designated contracting parties. The proposed fee level to be charged by the registry will be set out in the subsidiary legislation to be made under the proposed 19EA of Tiempo or Clause 13 of the bill, and will be subject to negative vetting of this Council. The Bills Committee notes that the administration has secured the in-principle support of the CPG for the proposed application of the Madrid Protocol to Hong Kong, and upon completion of all the preparatory work, will seek Central People Government's formal agreement. Upon its formal agreement, CPG will need to send a formal notification to WIPO on the application of the Madrid Protocol to Hong Kong. In this regard, a member has sought details of the support by CPG and the acceptance of WIPO, and inquired whether there are any conditions attached to CPG's support. The administration has advised that according to the Madrid Protocol, only states that are parties to the Paris Convention for the Protection of Industrial Property and qualified intergovernmental organizations may become contracting parties to the Madrid Protocol. Hong Kong, as an SAR, cannot be a contracting party. China has been a contracting party to the Madrid Protocol since 1995, but has yet to apply it to Hong Kong. According to Article 153 of the Basic Law, the application to the Hong Kong SAR of international agreements to which the People's Republic of China is a party shall be decided by CPG in accordance with the circumstances and needs of Hong Kong SAR and after seeking the views of the SAR government. The administration has further advised that it will, upon completion of all the preparatory work, seek formal agreement from CPG to apply the Madrid Protocol to Hong Kong. Upon the decision of CPG to apply the Madrid Protocol to Hong Kong SAR in accordance with Article 153 of the Basic Law, CPG will, as a formal procedural arrangement, need to notify WIPO of the application of the protocol to Hong Kong on a designated date. WIPO will then notify the contracting parties of the same. Meanwhile, the Intellectual Property Department has been in touch with WIPO on the operational details to prepare for implementation of the Madrid system in Hong Kong in future. The Bills Committee notes that the Madrid Protocol facilitates applications for trademarks registration among contracting parties to the protocol, but not among different constituent parts within a contracting party. Therefore, implementation of the Madrid Protocol in Hong Kong does not mean that the Madrid Protocol would then be applicable to trademark applications between Hong Kong and the mainland. Separate arrangements will need to be put in place if the Hong Kong SL government and the mainland authorities come up with any measures to facilitate reciprocal applications. Given that the mainland is the most important trading partner of Hong Kong, some members are of the view that special arrangements should be made as soon as practicable to facilitate filing of trademark applications between Hong Kong and the mainland. The administration has assured the Bills Committee that it will continue to follow up the discussion with the relevant mainland authorities on the possibility of putting in place separate arrangements to facilitate reciprocal trademark applications. In order to enable Hong Kong to reap the benefits of the Madrid system as soon as possible, the administration will, at the current stage, focus on the legislative exercise and other relevant matters. Some members have urged the administration to explore the feasibility or possibility of seeking mutual recognition of the registration of trademarks between Hong Kong and the mainland under the framework of CEPA and against the background of the Guangdong, Hong Kong, Macau Greater Bay Area. The administration has advised that trademark rights are territorial in nature and are granted in each jurisdiction independently in accordance with its laws and practices. Since Hong Kong and the mainland maintain separate trademarks regimes, it is difficult to put in place a mechanism for mutual recognition of registration of trademarks between the two places. As regards the possibility of other special arrangements, the administration has advised that it will continue to discuss with the relevant mainland authorities and has stressed that whichever arrangement or measure is to be adopted, it will have to be premised on the applicable provisions in Trademarks Ordinance and the relevant laws. The Bills Committee notes that the existing sections 93 to 96 of Trademark Ordinance provide for a number of criminal offense provisions against the acts of falsifying the register of trademarks, falsely representing a trademark as registered, and misusing the title of the registry, etc. Such provisions are currently enforced by the Hong Kong Police Force. Separately, Customs and Excise Department has been responsible for taking criminal sanctions against the copyright and trademark infringements under the Copyright Ordinance Cap 528 and the Trade Descriptions Ordinance Cap 362. The bill seeks to confer powers on CNED to enforce the criminal provisions under Trademarks Ordinance so that the enforcement of such provisions could be put under one roof as with those under the Copyright Ordinance and Trade Description Ordinance, i.e. with Customs and Excise Department. The Bills Committee notes that the criminal offense provisions under Trademarks Ordinance will no longer be enforced by Hong Kong Police Force after the commencement of the legislative proposal. Clause 15 of the bill seeks to add the proposed new sections 96A to 96L to Trademarks Ordinance to provide for the enforcement powers in relation to the offences under Trademarks Ordinance. The Bills Committee has considered the observations made by the legal advisor on various legal issues relating to the enforcement powers under the proposed new clauses. The Bills Committee has no objection to the resumption of the second reading debate on the bill, nor does it have any objection to the government's proposed CSAs on the new Section 96F2A to clarify its intention. The Bills Committee will not move any CSAs of its own. Madam Deputy, now I come to my own views on the bill. Madam Deputy, our Tiempo and TMR, that is trademarks rules, provides registration and protection of trademarks in Hong Kong to improve the regime as early back as in 2019, or rather in early 2019, the administration submitted the Trademarks Amendment Bill 2019 to the Council so as to put in place the Madrid Protocol in Hong Kong to provide convenient and expeditious means for registration of trademarks in Hong Kong. The Bills Committee completed its work in March last year. 2 meetings were held, including 1 public hearing. 19 deputations or individuals either attended the public hearing or submitted written submissions. I'm grateful to members of the Bills Committee and Secretariat staff of the Council and officials from the relevant bureaus and departments, and also deputation individuals who have made submissions to us. The Bills Committee supports the introduction of the Madrid Protocol in Hong Kong. As we all know, by means of a one-stop application process, a trademark owner can then have trademark protection in multiple jurisdictions. So it's just like a checklist. When you go to dim sum in a Chinese restaurant, you just take the dim sums you like and then place the order. This can help enterprises to obtain international trademark protection in a cost-effective and convenient manner. So myself and the DAB support the bill. There are 104 contracting states in the Madrid Protocol, including the Mainland, the U.S., Singapore, Japan, and South Korea, which have trade dealings with Hong Kong. The Madrid Protocol will offer a lot of convenience and cost-effective one-stop trademark registration process for enterprises. Trademark owners can just submit an international registration to WIPO, and by paying 1 fee, the trademarks can be given protection at various designated jurisdictions. This will greatly simplify the requirements for submitting individual filings in the jurisdictions concerned. This can lower the cost for seeking trademarks protection and reduce the possibility of mistakes, so that this will help SMEs with limited financial and human resources, and they can then expand their business in the world. So this is an option for trademark owners. Trademark owners can, depending on their own circumstances, choose how to register their trademarks. When enterprises consider whether they should make an international application under the Madrid Protocol, they must understand the feasibility of a trademark registration in a designated jurisdiction. If the trademark owner would like to extend their trademark protection to a couple of jurisdictions, they can still choose to follow existing practice, and that is to make individual filings in each of the jurisdictions concerned. If they want the trademark protection to be extended to multiple jurisdictions, then they can submit an international application to be more cost-effective. SMEs stand to benefit. Many small and medium-sized law firms are in support of applying Madrid Protocol to Hong Kong because many of these law firms offer trademark registration services. However, applications have to be filed to individual jurisdictions, with the exception of the EU. Solicitor firms will have to work through an intermediary in a related jurisdiction. They will add to the cost of operation, and therefore law firms cannot offer more competitive fees. And when enterprises make an application under the Madrid Protocol, they can further shorten the time and also the cost taken for registration. So the Madrid Protocol will offer one-stop convenience for law firms and SMEs. So SMEs will stand to benefit from the system in the long term. And if Hong Kong would like to be an IP hub, now, intellectual property rights are of high value. In other countries, they have valuation and insurance of IP rights, but Hong Kong is still at a starting point. I believe the system will help Hong Kong to develop it in the business of IP rights. In scrutinizing the bill, there was an issue that caused concern among members, and that is reciprocal filing of trademark applications between Hong Kong and the mainland, and how the process can be facilitated. Because of close business dealings between Hong Kong and the mainland, their views that there should be a system to facilitate reciprocal filing of trademark applications between the two places. This will enhance the business environment and will also be will facilitate growth of business in the two places. However, administration explained that the Madrid Protocol offers convenience for contracting parties. However, the purpose or the targets are not constituents within a contracting party. And so, even if we amend the bill to allow or to amend the ordinance to allow the application of Madrid Protocol in Hong Kong, that doesn't mean that the system is applicable to trademark applications between Hong Kong and the mainland. And therefore, there must be a discussion with the mainland on this matter. And the administration indicates that separate arrangements will have to be put in place. DAB is of the view that because of the GBA and the country's effort to promote import trade, there will be more business or trade movement between Hong Kong, Macau, and Guangdong. So we hope that the relevant departments can explore this feasibility proactively to achieve a win-win situation. For instance, one application applicable to both places to bring convenience to a trademark owner and to enhance integration of the two systems. And if special arrangements can be put in place to facilitate reciprocal filing, then it would even be better. We believe we can promote the IP registration business of both Hong Kong and the mainland. And the administration has assured the Bills Committee that will continue to follow up the discussion with the relevant mainland authorities on the possibility of putting in place separate arrangements to facilitate reciprocal trademark applications. I would like to know the progress of this discussion and whether, because of COVID-19, the discussion has been affected. And I'd like to know how the two places will continue with the discussion of this matter. The AIB also hopes that with the passage of the bill, the administration can publicize the new system to the industry, targeting SMEs in particular, so that they can be made aware of the new arrangements. They should have a better understanding of the new system. So there are views that we should provide more funding for promotion of the respect and protection of trademarks in Hong Kong. Since Hong Kong would like to develop into a World Design Center, World INT Center, and World IP Hub, the application of Madrid Protocol to Hong Kong is very closely related to the goals I just read out. This can help to enhance Hong Kong's competitiveness and reputation so that Hong Kong can have diversified and high value-added development. In the protection and promotion of intellectual property rights, this is most important. With these remarks, I support the bill and also the amendment.
Ivan Young. Mr. Richard, call for quorum. Mr. Richard, call for quorum.
法定人數已夠。
We had a quorum. Meeting resumed. Mr. Elvin Young. Honorable Member Lee, is trademark registration important? You just have to look at Air Jordan, New Balance, and Muji, and see what happened to them in China. And also, just fresh off the press, a few days ago, the Wanda Group is suing Disney for copyright infringement. You all understand that trademark registration is important to any merchant, especially in the globalized world. This is actually of utmost importance. Well, for this amendment bill aims for Hong Kong to implement the Madrid protocol and provide convenience to have one single application would allow in 122 countries to register. Even though for Hong Kong to implement the Madrid protocol doesn't mean there we have any deeper protection for trademarks. Only provide a one-stop application process to facilitate registration. However, I see that for Hong Kong businesses, especially those who would like to crack into overseas market, they have additional tool to deploy. So they don't have to do individual filings in each jurisdiction, which I see overall positive. So during the public hearing, and back in 2014 to 15, the public consultation conducted by the government, we heard a one-sided opinion, which is positive. However, the Madrid protocol, is that really that perfect and flawless? For example, let's say a company A, through a Madrid protocol, have applied for international specified trademark registration. In 5 years, is company A registration in Hong Kong is revoked or given up, and the 5 other international registration will also be void. The owner of company B would like to keep those international registration. Within 3 months, they would register the trademark in each jurisdiction one by one. While one may say this is a very remote scenario, we see something unlikely when the Cathay Pacific required government bailout. We can say never. Say never. Well, despite the drawbacks, we see that the enacting the Madrid Protocol is pros over the cons. While I would like to debate the merits of this bill on the structural level, in 1995 and 1st of December, become a contracting state to the Madrid Protocol. It stated that the Hong Kong and Macau is not part of the contracting parties because it's due to one country, two system. Because the Hong Kong and Macau trademark registration regime is radically different. 25 years on, the CPG have finally allowed the Hong Kong to join the party, so to speak, and agreed in principle to join the Madrid protocol. Even Madrid system, even Hong Kong, after joining, when the person applying for a global registration in the list of countries they can choose, China is actually not on the list. I remember the BC chairman Wang Ting-kwong said at the meeting, the major obstacle for Hong Kong company for trademark registration is China. But at the public hearing, including the DAB rep, also mentioned that the Nordic companies has spent a total of 27 months to register the trademark. And for Hong Kong companies to conduct business in the intellectual property held known as China, well, it should not be a political issue. That's why I quoted the views of the DAB deputation. What we should ask in that, why is it so difficult? Why the Madrid Protocol could not resolve this? according to the Hong Kong government, the Madrid Protocol is agreement between countries, and between the central government and the municipal government, this is not applicable. And then, Secretary for Commercial and Development agreed that they would expedite the negotiation and by way of administrative arrangement to resolve the problem of Mainland and Hong Kong registration. While Mr. Wang has spoken, in my Facebook, I got some messages by the public, and he claimed he was aware of debating this trademark bill. I have a company that somebody have stole my registration. Would this amendment bill able to help me? Unfortunately, even after this amendment bill, we're not able to help this cross-border small medium enterprises. And well, it's been over a year. Well, it was claimed, well, back in last March and on April, that yet to, well, the then secretary had always been transferred to the Secretary for Civil Service. So may I ask Mr. Edward Yao, what's the progress of negotiation, and do you have a plan and a timetable? And for the SMEs and for the bigger corporations, were they able to have any expectations in Hong Kong? Well, luckily, another perspective. Upon the passage of this bill, if a foreign brand, by way of the Madrid Protocol, to have apply for registration in Mainland and Hong Kong simultaneously, while they succeed in Hong Kong, they're not able to do so in Mainland. Why? Maybe the Mainland adopt the first past the post system. If someone is ahead of you, then you're not able to apply afterwards. And the registration regime is well, the polar opposites. It would not be surprising while you could succeed in Hong Kong but fail in China. Well, for the major brands like Muji, if they will be taken to court in the Mainland or even win the case, remember this. And early last year, the Hong Kong and China have already signed the arrangement on reciprocal recognition on enforcement of judgment in the civil and commercial matters by the court of Mainland and HKSAR, which also include the copyright infringement cases. If the Mainland winning party seek damages in Hong Kong, what will happen? Well, this global brand have able to register the trademark in Hong Kong, but actually be restricted by the law and not able to do their business. When global brands came across this obstacle, would that lead to a retreat from Hong Kong? I believe that the members from the commerce sector, for example, Mr. Michael Tian, mentioned while he had some personal experience, I believe that he would agree that the government should address this as concern as soon as possible. While, for example, to our Hong Kong companies or to foreign enterprises, would actually be nothing beneficial to them. Well, in this political environment, when the Beijing take a hard stance to implement the national security law, why the the companies will continue to invest in Hong Kong or the withdrawal is uncertainty. The intent of this amendment bill hopes to help the local SME to reduce its transaction costs and so to reduce the time spent on overseas registration. We still think it's worthwhile to offer our support for this bill. Upon the passage of this bill, we hope that the Director of the Intellectual Property Department or Mr. Edward Yao, the Secretary, could announce the details as soon as possible, and also the implement timetable as well, the relevant procedure rules, and also create a user-friendly platform so that to help those in need. I so submit.
Mr. Wu Ji-wei. The bill submitted a report to the House Committee of this Council on the 3rd of May 2019. So the scrutiny of the bill was completed earlier than the National Anthem bill. So if the administration really attaches significance to this bill, it should have been placed before the National Anthem bill. But of course, the government hasn't done so. Now, is this a bill really that important to the administration? From what I just mentioned, I believe we can make our own judgment. As regards whether the bill is as effective as the government claims, can it really enhance Hong Kong's IP trade as claimed by the government? I think it depends on the macro environment in the political and economic scene. Well, the government has violated one country, two systems, and a national security law is proposed. I'm sure it will undermine the effectiveness of the bill. A big question mark is cast. Now, the purpose of the bill is to put in place the Madrid Protocol in Hong Kong so that a trademark owner can make use of a one-stop application process to apply for trademark protection in multiple jurisdictions through international registration. However, whether the registration can be successful will depend on respective jurisdictions with consideration to their own laws and practices. So this is just a referral system. The actual vetting procedures are not fundamentally different from the current system. So when the administration claims that with passage of the bill, we can consolidate Hong Kong's position as an international city and knowledge-based economy, and that Hong Kong's business or position as an IP hub may be exaggerated, over-exaggerated by the government. More important still, from a macro point of view, will overseas businessmen come to apply for trademark protection will depend on whether there is any future in Hong Kong, what is the business environment, and Hong Kong's protection for businessmen and IP rights. Unfortunately, under the national security law, there is a big question mark here. Our protection for businessmen and protection for IP rights, will they remain the same? And there is an important issue under the bill. Because the Madrid Protocol is an international treaty, it doesn't apply to constituents of a contracting party, and therefore the protocol will not apply to Hong Kong and the mainland. And according to the government, it will continue to negotiate with the government to see whether administrative arrangements can be put in place to allow a certain degree of reciprocal filing of trademark applications between Hong Kong and the mainland. During the scrutiny of the bill, some members asked whether the administration could explore the feasibility of reciprocal recognition of trademarks in Hong Kong and the mainland. As I said, the protocol allows one-stop application process of trademark protections. I do not have strong views about this. If it can be done, of course, it will help Hong Kong businessmen to apply for trademark protection in the mainland. However, when it comes to reciprocal recognition of trademark registration, we have to be extra careful, because if there is real mutual recognition, then many unimaginable rulings in the mainland may affect our own system and undermine our system for IP protection, and therefore we must think twice. But of course, we have yet to see this reciprocal recognition system, so at least we can be assured for the time being. Should there be mutual recognition system to be put in place, the government has to consult the public and the council first before it starts to act. As Mr. Michael Tian said, more than a decade ago, his trademark was registered to the mainland by a mainland company, so his company was banned from selling certain products. So he had to went to the People's Supreme Court, and then the case was finally settled. There have been many trademark infringement. For instance, Muji, a Japanese company, when it wanted to enter the mainland market, it was found that its trademark was already registered by a mainland company, and then the trademark and the logo was very similar to its own. After a long court battle, the Japanese company Muji lost and had to compensate the mainland company holding its logo and trademark. I think this is just the tip of the iceberg. I think many Hong Kong and foreign companies have encountered the same fate. So if we start to have reciprocal recognition of trademark registration from now on, then the protection for our own trademark rights in Hong Kong will collapse at the same time at once. Using the same case I quoted now, Muji was registered in the mainland because of the reciprocal recognition. Then in Hong Kong, the trademark will belong to a mainland enterprise instead of a Japanese enterprise. I think it's all about the legal system and also the rule of law. When we were scrutinizing the bill, the government introduced the Fugitive Offenders Bill. Mr. Chung Kwok Pen and myself raised a similar concern, assuming that the director of a company was accused of breaching its trademark regime. Will that director in Hong Kong be arrested and extradited to the mainland? I think Mr. Felix Jones' question reflected our worry and concern and distrust for the whole system. Of course, the Fugitive Offenders Bill has been withdrawn, and many pro-establishment members may feel that they can be assured and they can continue to do business in Hong Kong comfortably. However, the National Security Bill is just looming at the corner, and the devastation to Hong Kong may even be more serious than the Fugitive Offenders Bill. In fact, the actual impact has yet to be assessed. Against this background, the reciprocal recognition of the ordinance may have a problem. Now, under Section 55 of the bill, now if there is a no against the use of a trademark, the bill cannot be registered. I have cross-checked similar legislation in the countries. There is a similar provision in the UK. As frequently said by the establishment members, other countries have also got their national security law. But the US and the UK are democracies, and they have a judiciary with a trust and respect of its people. Now, if the central people's government has escalated the issue of national security, now will the registration of trademark issue become a political issue? The bill may be passed today, but under some political circumstances, some organizations from some countries may not be able to apply for trademark protection as a result of the national security law. Now, in the company registry, they deal with the registration of company San Gong Man Si Ok, and the company registry, when asked by the media, said that it will not comment on individual cases. But Section 1700 of the company's ordinance said that a company can also be incorporated with a legal purpose, and it cannot commit any criminal offense or the breach of public interest. I understand that the CEO has the ROC has the duty to check the background of a company seeking to be incorporated. But why should it look into the background of the so-called members of the company, the brothers of the company? So this example shows that the business environment is not what it used to be. In the past, we knew what we are facing, but now everything has to be politically correct. The example I quoted is very relevant to the bill. Now, if a company seeks trademark registration, whether it be the US, the UK, or Taiwan, or an anti-Chinese country, will the trademark registry conduct political screening? Of course, the pro-establishment camp may say that we are just second-guessing their intention. For the business sector, they have more complicated consideration when it comes to political vetting, because that would raise the risk factor of their business. If Hong Kong is just a transit for their business, why should they choose to register their trademark in Hong Kong? Sino-US relations have deteriorated. We don't know what countermeasures will be taken. The Secretary for Civil Service recently said that our civil servants are not civil servants, not just civil servants of Hong Kong itself, but they are also public servants of the CPG. So is it true that in future applications from Taiwan will have to politically vetted if they are pro Taiwan's Progressive Party? They will not be considered. And will civil servants have to consider these factors before dealing with applications of this kind? Of course, the secretary will say that I was only taking matters to the extreme, and then I was just planting conspiracy theory here. Now, civil servants should consider matters in a professional matter, but in dealing with trademark registrations or applications, how can they totally avoid thinking it from the country's perspective? Now, if registration of trademarks face considerations mentioned by Mr. Patrick Nip, how can we ensure that there is no need to consider trademark registration from the perspective of the country? How can we ensure that the business environment in Hong Kong will not be distorted and out of shape? Under the national security law, the business environment will be affected, and even the whole civil service had to face a new scenario. We have to remember that we are member of the civil service of the CPG, and we have to bear this in mind when making decisions. Now, I think this will deal a heavy blow to our business environment. The central authorities would like to exercise as full sovereignty in Hong Kong. The national security law for Hong Kong has given them a concrete legal tool. They can use that as a tool to suppress the dissidents. Now, when we may want a country to be an IP hub, but I think this is just wishful thinking, because the Hong Kong is being sacrificed. There is only one country but no two systems. When overseas investors do not believe that we have one country, two systems, how can we promote our status as an IP hub? Thank you.
Mr. Holden Chow. Madam Deputy, the purpose of this bill is to enable Hong Kong to join the Madrid Protocol, so that when necessary, when you try to register your trademark in different countries, then after the enactment of this bill, you'll be able to apply for this one-stop service so that you don't have to apply individually to different jurisdictions for registration. I believe that that would also substantially save costs and time for the trademark owners. So that would also facilitate the enterprises so that they would be able to make use of this one-stop service to apply for registration in different jurisdictions. So that's the purpose of the amendment bill. It's very simple. But then today, when I heard the Berners members speak, they tried to bundle it up with the national security bill and how it's going to hurt our business environment. I think these are just bullshit. Because honestly, the national security bill is to enable us to have a conducive environment because just imagine if companies are not protected for their basic safety, then why would people come to Hong Kong to invest at all? So I think we will have to make it clear and we will have to refute the remarks. I do not understand why they would attempt to link it to the national security bill and they try to make remarks about this. Now let me turn back to the arrangements under the amendment bill concerning the Madrid Protocol. As I said, this arrangement is in line or would also save your efforts in making application with different jurisdictions concerning your trademarks. But then under the Madrid Protocol, it's not going to deal with the reciprocal recognition of trademarks between different jurisdictions. In simple terms, because, well, even within our country, we have the mainland, Hong Kong and Macau. So as a result of the Madrid Protocol, there is no question of this trademark being recognized both on the mainland and in Macau after it's registered in Hong Kong. In fact, the DAB, before the enactment of this bill, I understand that Mr. Ting-kwong has been liaising closely with different sectors. Mainly, we were discussing about Hong Kong enterprises or mainland enterprises. When they try to get their trademarks registered on the mainland, they've been encountering a lot of difficulties. And also given the prevailing climate, given the fact that there is no mutual recognition, they would have to go through different procedures. And in the process, that would involve a lot of time and a lot of efforts in getting the registration. And I understand that in the past, Mr. Ting-kwong and our DAB colleagues have been working to ensure that when you apply for a trademark registration in Hong Kong and on the mainland, there can be an orderly process so that we can save time and efforts in dealing with the trademark registration on the mainland. So that's been what we have been doing. And I also understand that well, in the process of the scrutiny of this bill by the Bills Committee, we've been talking about how we can promote the registration of the trademark on the mainland so that we can save some efforts, so that we would not be giving people the impression that it's a very time-consuming process before you can get your trademark registered on the mainland. So I believe that that's also what many members of the Bills Committee have talked about. And I'd like to take the opportunity to make this request to the administration. That is, well, of course, we know that Hong Kong and the mainland have different legal systems. So all we are trying to do is to ensure that Hong Kong enterprises, when they try to register their trademarks on the mainland, even if you are not allowing for reciprocal recognition, but then what we'd like to know is whether or not there has been discussion between the governments on both sides, or if you are able to give us a timetable as to Hong Kong enterprises, when they try to apply for registration on the mainland, that they be able to save time, or they do not have to make so much effort in completing the registration. So in terms of the progress, can you let us know? Well, as far as I'm aware, with regard to reciprocal recognition, there is still some way to go before we can achieve that. But then at least our enterprises or Hong Kong companies, when they try to register their trademarks on the mainland, at least they should be able to save time and efforts. I think that's a milestone. And if we can be given the timetable as to when we can achieve that, then the administration should let us know the progress. And I believe that is something that many of us would be very concerned about, and we would like to achieve that target. In any case, or the fact that we are able to join the Madrid protocol so that our companies will be able to save time so that they can apply on a one-stop basis for registration in different jurisdictions under the protocol. I think all in all, that would also facilitate our companies, and therefore I would be prepared to support the passage of this bill. These are my remarks.
Honorable Jeremy Tam. Thank you, Honorable Member Lee. First, we state that the Civic Party will support the Trademarks Amendment Bill 2019 for Hong Kong to enact the Madrid Protocol for better protection of the intellectual property IP. I hope that the IP will be to protect the intangible rights, while specifically speaking, it should include music, literature, and artistic work, and also inventions and discovery and symbols and designs that not, as so long as do not have a tangibility, will also need legal protection. As for the plagiarizing this intangible asset is too simple. For example, the Thomas Edison invented the light and tested 1600 materials. For other people to copy him, they could also save them some of the cost of failure. Without legal protection of this indivisible property, then nobody would be willing to invest the time and capital to innovate and to invent new things. Well, Hong Kong, along with the rest of the world, have laws to protect IP. In Hong Kong, literature, music, drama, and arts, film, broadcast are all protected by the copyright ordinance. And the trademark to differentiate the different merchants, we call it the description, the representation, design, and font, or even the packaging, has also been protected under the TMO. And the patent of invention is also protected under the patent ordinance. Well, what the copyright, trademark, or patents, these rights are also subject to geographical restrictions. Take trademark, for example. The trademark rights in accordance with their own jurisdiction and practice were granted independently. Thus, the rights are only limited to the registration when the place is made in Hong Kong, and the registration only valid in Hong Kong. It will not able to automatically apply to China and other jurisdictions. Thus, conventionally, if a business would like to protect their trademark by way of registration, they would also file applications one by one in each jurisdiction. Well, now that we have this global economy, if a trademark holder will need to file applications in each jurisdiction. In the process, if anyone with bad intentions would plagiarize the trademark and apply it ahead of the original patent holder, that someone would have get ahead of them, and the patent holder did not realize that the companies will expand abroad. When we need to venture into abroad, when making the application, they found that the trademark already been registered overseas. And most recently, we see the case that the Tono Causeway Bay bookstore, so that now they had to temporarily reopen in Taipei. There's somebody who had deliberately registered the name Causeway Bookstore in Chinese as a trademark or even as a limited company. To adjust the geographical restrictions, all the countries have entered into the Madrid Protocol so to effectively protect IP. The Madrid IP is managed by the WIPO, but allows the trademark holder through the local offices to submit the international application through the IB or WIPO and the applicant can specify the countries, the countries to which they're protected. The trademark holder automatically enjoys the convenience of, as opposed to in the past, request the applicant to file individual applications in each jurisdiction. Well, the advantages are obvious. So as long as the applicant make one international application and pay a one-off fee, and they can register the countries in many jurisdictions and reduce the time costs, and most importantly, they will not able to preempt any attempt to register ahead of them. Currently have 106 contracting parties, including most of the advanced economies, for example, the EU, US, Japan, and South Korea, and Singapore. And for the companies, individuals who wish to register the trademark, for Hong Kong to enter into the Madrid Protocol would definitely offer a protection of their IP. As Hong Kong have yet to be a contract party of the protocol, the Civic Party therefore have support this Trademarks Amendment Bill 2019 so that the Madrid Protocol can be enacted in Hong Kong. Even though we support this bill, that doesn't mean that we agree that upon being part of the Madrid Protocol, they'll completely eradicate the IP issues, especially on the issue of mainland plagiarism. For the contracting parties to the protocol, that the empire of bootleg, that China is actually one of the signatory of the Madrid Protocol. It shows that the WIPO and other global organizations facing the same problem. There's no effective execution mechanism to deal with any breaches. If member state deliberately breach the agreement that is supposed to provide that the IP protection will be much undermined. While there are so many counterfeit brands in China, while classic example being the New Balance suing New Balance and Xiaodan Sports suing the Michael Jordan. So the bootleg brands actually suing the genuine brands. But why the mainland trademarks originally conferred the trademark to the first applicant? The mainland court would frequently award the victory to the counterfeit brands. Well, the famous Japanese brand Muji, after entering China, they were sued by a company called Natural Mill, who had the same name in Chinese, and accused that the Muji are plagiarizing the bootleg label. You can see it's quite similar. However, the left as being the Muji, while the right is the bootleg. As ridiculous as it is, the Chinese court have awarded judgment to the Natural Mills and request the Muji brand to stop using the trademark Muji, and the Japanese Muji would need to stop using the trademark declaration in Tmall and the physical stores. And the Chinese court have also decided that the Muji will need to compensate the Natural Mills 626,000 renminbi dollar. While it was a small sum, however, with all the restrictions placed in the physical stores in selling their merchandise, or even issue a statement that they would give up the trademark Muji, I see that I completely confused who is really the genuine brand. While the Muji is only able to operate under an English name in China. Well, what I said is just tip of the iceberg. There are other countless bootleg brands have yet to brought to court. Even what the genuine brand have won the case to spend years and lots of costs. And even for Alibaba former chairman Ma Yun once said that that the fake ones don't appear as inferior as the genuine ones, and with much better prices. Well, they just stated out in the open that we are just thieves. However, our loot is much better than your genuine articles, and it shows that let's see how widespread this disrespect towards IP is in China. In 2019, we support this Trademarks Amendment Bill so that the Madrid Protocol can be implemented in Hong Kong. However, we hope that while joining the Madrid system, you can take note that some countries or regions have yet to respect the IP. The government should warn this country's jurisdiction. If they stop respecting the IP, they'll become the laughingstock of the world and isolated by the civilized world. I so submit.
Does any other member wish to speak? If not, I now call upon the Secretary for Commerce and Economic Development to reply. Then the debate will come to a close. Secretary. President and members, the government tabled the Trademark Amendment Bill 2019 in the Council in February 2019. We are grateful to the chairman of the Bills Committee, Mr. Ting-kwong, and its members for their efforts and support in completing the scrutiny of the bill in April last year. And I want to thank all members who have spoken just now for the support of the bill. Although some members have made comments that are not really entirely relevant to the bill. And therefore, in my reply, I'd like to reiterate the purpose and legislative objectives of the bill.
There are three parts in the legislative proposals. Part 1 amends the TMO to enable the Madrid Protocol to be applied in Hong Kong so as to implement the international registration system under the protocol. It would enable the owners of trademarks to apply for the registration and management of their trademarks in multiple jurisdictions via a one-stop process. The implementation of Madrid Protocol in Hong Kong will not only enable enterprises to save time and cost in obtaining and managing international trademark registration, but can also tie in with the administration's target in improving Hong Kong's IP system. Part 2 of the bill seeks to authorize the C&E Department to enforce the criminal provisions of the TMO. At present, it's the police force that is responsible for law enforcement, but as the C&E Department has been responsible for combating infringing acts on copyright and trademarks, we suggest that enforcement work relating to trademark registration should also be handed over to the C&E Department to make the relevant enforcement arrangements more comprehensive. Part 3 of the bill is some technical miscellaneous amendments to enhance Hong Kong's TM application and registration system. During the scrutiny stage of the Bills Committee, members generally supported the bill. Moreover, overwhelming majority of those who submitted written submission and were attended the Bills Committee's meeting also show their support for the bill. Some members of the Bills Committee suggested that in view of the close connection between Hong Kong and the mainland, special arrangements should be put in place to facilitate mutual submission of trademark application. So just now, for those members and the chairman of the Bills Committee who have spoken, agreed to this. And therefore, we believe that we should set up a mutual recognition mechanism between Hong Kong and the mainland. But then I have to emphasize that the Madrid Protocol is an international treaty which is not just applicable to the reciprocal recognition between different places, and the nature would also be subject to the geographical locations, and also the respective jurisdictions would also be acting in accordance with their own systems in awarding trademark registration. So that would not be changed because of the application of the Madrid Protocol to Hong Kong. And therefore, so the Madrid Protocol is not about reciprocal recognition between different places in terms of trademark registration. In fact, both Hong Kong and the mainland have their own respective registration system, and therefore they would also be looking at how they can protect their own trademarks and so on. And therefore, we will try our best to do this. And the IP system on the mainland is totally in line with the WIPO and other international standards. And therefore, under these international conventions, IP protection is also subject to the geographical situation, and there are also international mechanisms to enforce such trademark protection. But then, in view of the fact that some members have said that between us and the mainland, there might have been some commercial disputes and so on. But then, as we have promised at the Bills Committee, we'll be talking to the mainland authorities on IP protection, and we will continue to follow up on this with the relevant mainland counterparts. Upon the passage of the bill, all provisions except for Clause 5 and Part 4 will come into effect on the same day of Gazetto, as Clause 5 and Part 4 of the bill involve the right to apply for international trademark registration in Hong Kong under the Madrid Protocol. The commencement date for these provisions will have to wait until after we have completed the other preparatory work, including the support network and so on. With regard to the commencement data for the Madrid Protocol, we will have to get the consent of the Central People's Government on the commencement date. Well, the CPG has already indicated that it would be prepared to support it, and we will be following up on these after the passage of this bill. I will be moving a simple committee stage amendment later to add to the new clause 96F to A the word willfully in the English version, and also 故意 in the Chinese version, to illustrate more clearly the mens rea of the relevant offence of willfully obstructs an authorized officers in the exercise of his powers and the performance of his duties and so on. And the Bills Committee has no objection to this. I urge members to support the bill and also the amendment that I'll be moving in the committee stage to enable the early implementation of the Madrid Protocol in Hong Kong to facilitate the operation of both local and overseas enterprises. Thank you. I now put the question to you, and that is the Trademarks Amendment Bill 2019 be read the second time. Will those in favor please raise their hands? Those against please raise their hands. I think the majority of the members present are in favor. The bill is passed.
Trademarks Amendment Bill 2019. This council now become committee of the whole council to consider the trademark